Good afternoon, everyone. Welcome to Comcare's webinar, Contractor Management and Regulatory Process Enhancements. My name is Tom Dawson, and I'm the Director of Regulatory Operations Group here at Comcare. I'm pleased to be your host for today's event. Before we officially get started, on behalf of Comcare, I'd like to acknowledge the traditional owners on the lands on which we are virtually meeting today. I'm joining from Adelaide, so I'd like to acknowledge the Kaurna people who are traditional custodians of this land. I'd like to pay my respect to their elders past and present and acknowledge the contribution they have made and continue to make. I also extend that respect to other Indigenous Australians and Torres Strait Islander people who are present. I acknowledge all of you are here today. Excuse me. Feel free to share where you are joining us from in the meeting chat. Now for some general housekeeping. Firstly, it's important to note that this session is being recorded. However, only myself and the other presenters will be captured in the recording. So you will notice your microphone and camera are not able to be turned on. However, we're keen for you to engage and interact throughout the presentation through the chat function. We do, of course, ask that you keep the chat respectful and on topic. If you're using the Microsoft Teams app, there are instructions on the screen and in the chat on how to turn off chat notifications during this webinar, as some people find these distracting. If you do encounter any technical difficulties, such as audio or video problems, please try refreshing your browser or rejoining the session, as this often resolves the issue. There will be 4 poll questions asked during the webinar, and a prompt on your screen when each of those questions is live, and I'll remind you of those as we go through. However, we do know that the technology settings on some external organisations can limit access to polls. So if you do have difficulties, you're still welcome to respond through the chat instead. The recording of this webinar and other resources will be made available on our website in the coming weeks. If you do find the content in today's session to be distressing to the point you need access to support, we have posted links and contact numbers to support services in the chat if you require them. Okay, before we dive into the webinar topics, I just want to use this opportunity, as there's a lot of you out there, to raise awareness around a couple of things. Firstly, if you're not aware, the Comcare National Conference will be held on the 20th and 21st of August this year in Canberra. The theme, Collaboration for Prevention and Change, will explore creating safe and healthy workplaces and sustainable return to work practices through strong leadership and inspired action, continuous improvement and future-focused approaches. Leveraging collaborative relationships, the conference will focus on prevention and return to work best practices in an ever-changing workplace. The registrations will begin in March, and you can stay up to date by subscribing to Comcare's e-news or on LinkedIn. We're currently calling for abstracts for the conference program, and we're interested in case studies, sharing better practice and lessons learned. If you'd like to find out more information, head to the conference website. We'll add that link into the chat. Secondly, I want to bring your attention to work health safety law reform changes. These bring significant changes, including the introduction of, firstly, an industrial manslaughter offence, substantial penalty increases, and the establishment of a family and injured workers advisory committee. These changes aim to enhance workplace safety, address community concerns, and hold entities accountable for breaches. The industrial manslaughter offence becomes effective on the 1st of July 2024, with most other amendments already in effect since December 2023. To stay informed, again, visit the website provided in the chat and on the slide. Thank you. We'll now move on to the webinar. We have 2 sessions outlined today, first one being Contractor Management, which will be presented by Bev Smith, Michael Evans and Phil Devney from our Regulatory Operations Group. This session will cover shared duties and monitoring requirements when engaging contractors, and what to expect when an inspector calls, following an incident involving contractors. Following that, Peter Davis, also from the Regulatory Operations Group, will discuss recent regulatory process enhancements. The purpose for this is to provide an update on these processes, which have been enhanced to ensure targeted and effective assessment and prioritisation of Comcare's regulatory responses. Today's webinar has been shaped in response to the questions received during registration, and we have considered these within some of the scenarios and examples that we're going to unpack throughout the webinar. While we won't cover every aspect, we aim to address a wide range of your inquiries and provide valuable insights for you to take away. I'll now hand over to Bev to start our webinar. Thank you.
Thanks, Tom. I'm Bev Smith, Senior Director of National Operations for the Regulatory Operations Group here at Comcare. I'm joining you from the lands of the Gadigal, part of the Eora people. With me today is Michael Evans, Director of our Regulatory Operations in WA and our Major Infrastructure Program. Joining us is also Phil Devaney, an Assistant Director in Regulatory Operations in Victoria. It is a pleasure to be here with you today to discuss contractor management, another important topic for the health and safety of the jurisdiction. However, before I commence, I need to clarify that throughout the presentation, when I refer to the contracting PCBU, I'm speaking about the person conducting a business or undertaking who is outsourcing or contracting the work to be performed. Now, why the focus on contract management? Comcare is a data-led regulator, and contractor management will always be a priority for us, but it is also one of the regulatory priorities for 2023-24. In 2023, about a third of the notifiable incidents that were reported to Comcare indicated the involvement of a contractor, and about 1 in 10 work health and safety concerns received by Comcare also involved a contractor. Many of these concerns related to unsafe work practices. These incidents occurred across a range of industries within the jurisdiction, involving workers in office-based roles through to those working in construction. The vulnerability of contractors to a greater risk of injury, illness or death compared to other workers performing the same work has also been identified as a persistent challenge in the current Australian work health and safety strategy. So let's discuss why contractors would be more vulnerable to an increased risk of injury, illness or death. Firstly, unfamiliarity with the worksite and safety management system. While they may have been engaged for a particular expertise, they will not be as familiar with the worksite, the particular risks and hazards present at that worksite, the emergency management procedures, nor the contracting PCBU safety management system. Secondly, economic incentives. Many contractors are paid according to their output, for example, the number of deliveries a contract driver makes. This means they may be incentivised to take shortcuts to complete the work as quickly as possible and ignore safety protocols. The contract may also be fixed price, so there may be a disincentive to request more resourcing if this is required. Thirdly, contractors are less likely to report safety issues or incidents due to the more precarious nature of their employment conditions. Another issue for contractors can be communication barriers because they're outsiders and may not have access to the same information flows. Differences in safety culture can also be an issue. Contractors can be smaller operations and may not have safety systems and a safety culture as mature as a larger business. I will now briefly recap some relevant work health and safety duties. So despite the challenges we just discussed, outsourcing work to contractors does not remove a contracting PCBU's obligation to ensure the health and safety of its contractor or subcontractors. A work health and safety duty cannot be transferred to another person. Effectively, a PCBU has the same responsibilities to its contractors as to its direct employees, and this is reflected in the Commonwealth Work Health and Safety Act, which states, "A person is a worker if the person carries out work in any capacity for a person conducting a business or undertaking, including work as an employee, a contractor or a subcontractor, or an employee of a contractor or subcontractor." The primary duty owed by PCBU to all its employees and workers is set out in Section 19 of the Work Health and Safety Act. This requires the PCBU to ensure, so far as reasonably practicable, the health and safety of all its workers while at work, including contractors. There are a number of things a PCBU must take into account and weigh up to determine what is reasonably practicable to ensure health and safety of its workers, and these are set out in Section 18 of the Work Health and Safety Act. Relevant to contractor management, one of the matters to take into account is what the PCBU knows or ought to reasonably know about the hazard or risk and the ways of eliminating or minimising it. It is not reasonably practicable to manage a risk you don't have knowledge of. This is an objective test. It is not just what the actual knowledge was at the time, but encompasses knowledge of hazards and risks that the PCBU ought to know, given their expertise and experience. In many contracting arrangements, a PCBU is engaging a contractor for expertise in a work activity they don't have themselves. The case law makes it clear that a PCBU is entitled to rely on expertise of others to manage work health and safety risks. However, this does not absolve them of their duties. As the contracting PCBU, your responsibilities are qualified by the term reasonably practicable, and the difference in expertise between the contracting PCBU and their contractor is a crucial consideration. What will be reasonably practicable to do in terms of managing work health and safety risks will be more if the contracting PCBU has relevant experience and expertise in the work they are contracting out than if they have no expertise. It is also not reasonably practicable to affect a matter over which you have no control. The capacity to exercise influence and control over a relevant matter will also determine what is reasonably practicable. This is another concept important in contractor management arrangements, where you have more than one duty holder responsible for ensuring the safety of all workers, and each will have varying levels of influence and control over the activity. The importance of influence and control in determining the relative extent of a PCBU's work health and safety duties is reiterated by Section 16 of the Work Health and Safety Act. This provides that more than one person can concurrently have the same duty. If more than one person has a duty, such as a contracting PCBU and its contractor, each person retains responsibility for their duty and must discharge that duty to the extent they have the capacity to influence and control that matter, or would have had the capacity but for an agreement or arrangement purporting to limit or remove that capacity. So what does all this mean? Firstly, it is very clear that you cannot contract out of a work health and safety duty by limiting your control over the activity through some artificial legal construct in the contract. The courts will consider the agreement, but to determine what was reasonably practicable for both parties to do to meet their work health and safety obligations, they will focus on each duty holder's expertise and actual ability to influence and control the activity. Note also, artificial arrangements put in place to minimise legal risk can also increase work health and safety risk due to the fact that they encourage an arm's length approach by the contracting PCBU, meaning they do not appropriately engage in managing the risk or discharging their duties. Secondly, to have the ability to influence and control, you must have a certain level of expertise and access to the work being performed. The Reilly and Devcon case we will discuss shortly has a tidy definition of the control of work. For control to exist, it must contain an element of knowledge, skill and experience, and the ability to recognise the need for corrective action and the power to enforce it. Now, control may arise from the legal ability to take control of the work activity under the terms of the contract, or from the practical ability to do so. For example, by being able to practically direct the work because you're in a position to monitor the activity and you have the knowledge of how it should be done safely. The control referred to is actual control over the particular matter affecting safety. For example, if there's a work health and safety incident, the relevant control is over the specific activity that resulted in the incident, rather than general responsibility or control over the work site, which is referred to as general control. The more control or influence over work, the greater steps that need to be taken by the PCBU to discharge the duty. Now let's look at some different types of contractors and how these concepts might apply. PCBUs engage contractors for various reasons. One end of the spectrum is where the business has the expertise and just wishes to supplement this with additional labour, such as labour hire. The other end of the spectrum is where a PCBU engages a specialist contractor and the contracting PCBU has limited or no expertise. I'll discuss both in more detail. Firstly, labour hire. The service would have historically been done by the PCBU and the contracting PCBU in this arrangement usually controls the day-to-day activities of the workers in an environment where they integrate with the direct employees of the company. Contracting PCBUs should treat these workers for all intents as if they are employees in terms of meeting work health and safety duties. Most employers meet their obligations to employees through a safety management system, and therefore the host PCBU should induct labour hire staff into their safety management system and closely supervise their compliance with that system. This includes ensuring labour hire workers are incorporated into the work health and safety consultative and representation arrangements. The labour hire firm also has responsibilities directed at ensuring the host PCBU meets its work health and safety responsibilities while its workers are on site. Case law makes clear that lack of control over the work site is not a defence for labour hire companies, or in fact anyone who has employees working in third-party premises. A labour hire company needs to adopt a positive and proactive approach with the host PCBU to require steps to be put in place to avoid risk to the worker's safety as a condition of making the worker available. If they are not able to satisfy themselves that the arrangements put in place by the host employer assure the safety of the workers, then they can withdraw labour. At the other end of the spectrum are specialist contractors engaged by the contracting PCBU to perform work they do not have expertise to perform or supervise. Examples are electricians, plumbers and other specialist trades which require licences and qualifications, or a specialist construction contractor engaged as a principal contractor to undertake construction work. They are still workers and still owed a duty of care, but as we have discussed, the contracting PCBU's duty is limited to matters they can reasonably control and influence. In many instances, there will be limited scope for the contracting PCBU to exercise control over the detailed manner of performance of work by specialist subcontractors. The case law makes it clear there is not a general obligation to supervise a specialist contractor, and there is no expectation that a contracting PCBU engage a second expert to oversee the method of work adopted by the first expert subcontractor, as this would require a doubling up at a significant cost. But while the contracting PCBU might not have the expertise to oversee the detailed method of work being undertaken, or only have limited access to the worksite, this does not mean they're excused from taking reasonably practical measures that are within their control and expertise to ensure safe working practices are adopted. In the case of specialist contractors, given that contracting PCBU is relying heavily on the expertise of the contractor, the main control and influence they have is in the selection of the contractor and the contractor itself and the contract itself. Critically, they need to ensure the contractor has any licenses, the experience and the competencies to perform the work, and that they present to the PCBU on how they plan to conduct the work safely. The contracting PCBU can also exercise power to suspend or cease work if they observe conduct that does not conform with understood safety requirements of the activity or the workplace in general. So we've looked at what requirements are on a contracting PCBU from both ends of the contracting spectrum. We'll now look at examples from case law. While these cases all involve construction, the principles are applicable to all types of work. Let's start with Really versus DevCon, which I mentioned earlier. In this case, a worker of a subcontractor died as a result of the collapse of a building under construction. DevCon was the PCBU in charge of the development on site. It engaged labour and ordered materials needed for the building process. The subcontractor had been engaged by DevCon to provide all necessary labour on site for the supervision and erection of all structural steel and concrete tilted panels on the site. The reason for collapse was that there was inadequate lateral restraint of the steel beams. The court accepted that DevCon had no legal right to direct the subcontractor as to the appropriate means of providing adequate lateral constraint to the steel beams, and accepted that the lack of adequate lateral constraint was not apparent, nor would it have been apparent to DevCon given its lack of relevant expertise. It was also accepted that the subcontractors' employees took direction on how to work was to be performed from the subcontractor, and had DevCon's supervisor instructed them, they would not have regarded themselves as obliged to follow. The court found that while DevCon had control over the whole workplace at the time of the incident, general control, it was not considered reasonable for them to have knowledge and skills that the subcontractor had to carry out the specific work which led to the fatality, meaning DevCon did not have actual control of the work that resulted in the fatality, and therefore could not have taken further reasonably practicable steps to prevent the incident. I'll now compare this to a more recent case, Safe Work New South Wales versus McConnell Dow Constructors, in which the court found the contracting PCBU who engaged an expert subcontractor did breach its work health and safety duties because it did have a level of control that it could have exercised to prevent a fatality from occurring. In this case, a fatality occurred on Sydney Harbour. The defendant, McDonnell Dow, subcontracted out work to Brady Marine for the new Barangaroo ferry hub. Brady Marine was a specialist contractor in marine piling and working on barges. Brady Marine was undertaking piling work and removing headstocks, which are large metal beams. These were then placed upright on a barge. These headstocks were not secured to the barge, and consequently one toppled when it was accidentally hit by a crane, killing a Brady Marine worker. McDonnell Dow sought to rely on the fact that Brady Marine was specialised in the work, which they argued limited their duty to ensure a safe system of work, asserting only Brady Marine was responsible. The court rejected this. They said, while a PCBU can call upon expertise which it does not have itself, in this case, McDonnell Dow had the same expertise in this specialised marine construction task as Brady Marine. A counter example would have been if the work involved Brady Marine's divers conducting underwater work in relation to the piling, which the McDonnell Dow did not have expertise. The court found in this case McDonnell Dow did have control over Brady Marine because it had an obligation under the contract to inspect the worksite daily and a right to stop work at any time on safety grounds. McDonnell Dow had not inspected the worksite on the day of the incident or the day before. It was therefore not aware of the risk, but it should have been. This was not a case where the contracting PCBU engaged a skilled contractor who had knowledge of appropriate safety precautions that the contracting PCBU did not have. This was a case where it was reasonably practicable for the contracting PCBU, McConnell Dow, to give instructions on how the work was to be done and what safety measures were to be taken. Relevantly, every employee of McDonnell Dow that gave evidence in the trial knew ways of eliminating the risk posed by the unsecured headstocks. McConnell Dow was found guilty and fined $500,000. Similarly, in Henson versus ABB Australia, the contracting PCBU ABB pleaded guilty to a breach of the Work Health and Safety Act when a labour hire employee fell 3.5 metres through a void and sustained spinal fractures. ABB had extensive safety systems in place and had identified the need for all workers to wear harnesses that were exposed to the risk of falls. The supervising foreman of ABB asked the labour hire employee if they wanted to wear the harness. They declined. The court found that the supervising foreman should have required this. These three cases span specialist contractor to labour hire arrangements and demonstrate the considerations that are relevant to assessing the level of control a contracting PCBU has over the actual work being performed by the contractor, and hopefully give you a better understanding of these concepts. I would now like to discuss the practical measures a contracting PCBU can take to meet its work health and safety duties to contractors. Generally, a PCBU will satisfy its work health and safety obligation to all its workers through the development of a safety management system to which all its workers must comply. In relation to contractors and the work health and safety challenges associated with these arrangements, an effective way to ensure the contracting PCBU meets its work health and safety duties is through the establishment of a contractor safety management system that is aligned with overarching safety management system and procurement processes. This system should identify, communicate, confirm and verify safety requirements through the procurement and life cycle of a project. I will now go through the essential elements of a contractor management system as depicted in the model on the current slide. The practical level at which this system needs to operate to ensure work health and safety duties are met will depend on the type of contractor engaged, the level of risk associated with the work being contracted, the level of control and expertise the principal PCBU has over the work, and their access to the work site. These considerations are relevant to considering what a PCBU can reasonably practically do at each stage of the contract management process. The first element of any contractor management system is to scope the work to be performed and the work health and safety requirements. This will help you plan the selection of an appropriate contractor and structure your contractual arrangements to support the effective management of work health and safety between the respective parties to the contract. This requires, firstly, defining the work to be done and the environment in which it will be done. Will the contractor have management control over the working environment? Will there be interaction with your employees or other workers? And what access will you have to the work environment? Secondly, you need to identify the type of contractor support you require. Do you just need to supplement labour in an area you already have expertise, or do you need a specialist contractor? Thirdly, you should identify what are the risks that may arise in the performance of the work. To do this effectively, you may need to undertake a high-level risk assessment to identify what will be required both in the contract and in the contractor selection process to manage these. For example, you may identify that you need specific provisions to give you assurance that specific work health and safety risks will be managed effectively. For example, in tunnelling infrastructure projects, it is common to see very specific provisions regarding air monitoring that the successful contractor must comply with. You should also consider whether at this stage you can design out some of the risks in the project. The next element is selection of a suitable contractor. This is a critical aspect of contractor safety management and a reasonably practicable step that all PCBUs can take to ensure the safety of all workers. In fact, this is crucial if you're engaging a contractor for expertise that your organisation does not have. When selecting a contractor, you should firstly consider the values and systems of the contractor from a safety perspective. A safety-conscious contractor will identify risks and eliminate them, thus augmenting the effectiveness of the contracting PCBU's own safety management system. And vice versa, contractors with deficient systems and culture will create vulnerabilities in the contracting PCBU systems. Therefore, ensure you interview key personnel to assess their values and approach to safety. Other things to consider: do they have a record of good safety performance? This can be assessed through safety records and references relating to the contractor's experience in similar projects. You must verify the contractor holds all relevant qualifications, licence and certifications if they are required to perform specific tasks in the contract. You should request and review contractors' work health and safety policies, procedures and risk assessments to ensure compliance with industry standards. And if you're using a panel, which is common in the Commonwealth, ensure that they have already been vetted for safety as part of the panel selection process using the above considerations. The next important element is the contract itself. This regulates the relationship between the contracting PCBU and their contractor. You need to seriously consider how you can use the contractual obligations to best facilitate a successful legal relationship with the contractor to meet work health and safety duties. You should consider mapping work health and safety duties and clearly outlining work health and safety responsibilities in the contract, including provisions to give assurance that high work health and safety risk will be managed effectively. Define reporting and communication channels for safety issues and incidents. Set out expectations regarding incident investigation and timely access to information collected and any investigation reports. Set out how work health and safety performance will be monitored and reported on so you know they are fulfilling their work health and safety duties. Set out the work health and safety issue resolution processes in relation to any safety dispute arising with the contractor over the provision of services. Define how consultation with other duty holders will occur, including all contractors, subcontractors and their workers. Consider what level of contractual control the contracting PCBU will have. Will you be able to direct activity being performed and be able to stop work? But, as discussed above, work health and safety duties are not transferable, and the courts will look beyond the contract to determine what actual control the contracting PCBU could have asserted, given its expertise and practical capacity to supervise the work. Therefore, the contract provision should support a position where all parties to the contract are accountable for doing all they can reasonably practically do to minimise risk to health and safety, rather than artificially trying to limit liability. This will give everybody the best protection, including the workers. The next element is contractor onboarding and induction. As we discussed at the beginning, one of the challenges placing contractors at greater risk of injury than other workers performing the same work is their lack of familiarity with the work site and the policies and systems in place to protect the safety of all. They may also have a more limited understanding of the contracting PCBU's expectations regarding health and safety generally. One of the best ways to address this risk is through adequate onboarding and induction. This should ensure contract workers are aware of your organisation's safety policies and procedures, including communication and representation arrangements, incident reporting, and any site safety rules. It should verify that contract workers have undergone appropriate safety training and have the competency and certification for specific tasks, including having documented proof when they attend site. It should ensure contract workers are aware of the emergency evacuation procedures and location of facilities. Importantly, it should enable the sharing of information on site-specific hazards the contractor may encounter, their controls, and how these might interact with any risk arising from the contracted work. Therefore, the induction should be tailored to the activity being performed. It should also be tailored to the audience. You should consider if the contractors have other vulnerable characteristics which compound work health and safety risks. For example, if they are culturally and linguistically diverse. If this is the case, it is essential to ensure that the information imparted is understood, and the principal PCBU should have some mechanism to verify this. The Commonwealth's Work Health and Safety regulations require that any training must be provided in a way that is readily understandable by any person to whom it is provided. The next element is planning a safe system of work. Prior to allowing work to go ahead, a contractor must provide, and the contracting PCBU must review and approve a plan to undertake the proposed work safely. This can be a safety management plan or a safe work method statement, commonly known as SWMS, or something equivalent depending on the type and complexity of the work. The construction safety regulations require that a safe work method statement is prepared before high-risk construction work commences. This must identify the high-risk construction work, the hazards and associated risks to safety, the control measures and how these are to be implemented, monitored and reviewed. While SWMS are only required for high-risk construction work as defined in the Work Health and Safety regulations, these are a good template that can be used for other contract work to demonstrate that the contractor has identified the hazards and risks and has a planned safe method of work. While the form of the document is not important, evidence that this has been done effectively is required to meet both the contractors and contracting PCBU's duties under the Work Health and Safety Act and regulations. To the extent the contracting PCBU has the expertise and experience to do so, it should be involved in the development and approval of the safety plan, and the workers should be consulted to ensure it covers all hazards and risks and reflects work as done and not work as imagined. The plan should be a living document and should be reviewed if there is a change to the work or there's been a work health and safety incident. In planning safe systems of work, you should also confirm emergency preparedness of the contractor. The next element is contract monitoring and supervision. The purpose of monitoring contractors post-engagement is to ensure they are conducting the work safely by implementing the processes they have described in their work health and safety systems and safety plans, and that these remain current and relevant for the work they are actually conducting. To do this effectively, you should ensure there is a clear process for all contractors to report incidents and near misses, and for these to be investigated promptly and thoroughly and corrective actions implemented. You should conduct regular performance reviews of the principal contractor and subcontractors to assess the effectiveness of the work health and safety management systems and update safety procedures in collaboration with the contractors. You will also need to determine what level of supervision is required by the contracting PCBU over the contractor. As discussed earlier on, this will depend on what level expertise the contracting PCBU has in the work. The more expertise they have, the more reasonably practical steps they have available to them. It will also depend on practical access to the workplace, the extent of the work being performed, is it a one-off visit or ongoing work, and importantly, the level of risk of the work being performed. It is recommended for large projects that the contracting PCBU map out the risk profile of the project, which will highlight activities which require more supervision. For longer-term projects or those with high-risk activities, a systematic approach such as independent inspections and audits should be considered. This will give the contracting PCBU continuing assurance that the contractor's safety management arrangements continue to operate as intended and remain effective in managing work health and safety risks, particularly as the project evolves. The last element is handover and closeout. It is important to ensure there is a thorough handover process at the end of the activity or project, including handover of all safety documentation, and that the lessons learned from the project are captured for future projects. I will now discuss the 3 C's which underpin any effective safety management system. There is an ongoing duty under the Work Health and Safety Act for the contracting PCBU and all its contractors to consult, cooperate and coordinate activities with each other for the life of the contract. The Work Health and Safety Consultation, Cooperation and Coordination Code of Practice provides that the objective of consultation is to make sure everyone associated with the work has a shared understanding of what the risks are, which workers are affected and how the risks will be controlled. The exchange of information will allow the duty holders to work together to plan and manage health and safety. Note the plural, duty holders. Practical ways this can be achieved are through the establishment of clear lines of communication between the contracting PCBU and its contractors, particularly regarding the notification of changes in process and deviation from agreed approaches. You should implement regular safety meetings attended by both the contracting PCBU and all its contractors to discuss safety performance and improvements, to address safety issues and reinforce safety expectations. Contractors should be encouraged to report safety concerns without fear of reprisal. There may be a reluctance to do this due to the vulnerability of their employment arrangements or time-critical contracts. You should also ensure contractors are embedded in health and safety representation arrangements. So that covers all the elements of a contractor management system. What has been described is very comprehensive. However, not every contract arrangement will necessitate this depth of scrutiny. And depending on the type of contractor engagement, there will be more focus on certain elements than others, as I touched on earlier when I looked at labour hire versus expert contractor arrangements. I will now hand over to Mike Evans and Phil Devaney, who will discuss how inspectors approach the assessment of the respective work health and safety duties in these complex arrangements, and provide some examples of what might be considered reasonably practical to do in some of the more common contracting arrangements we find in our jurisdiction. However, ultimately, it is up to you to determine with your subcontractor how you will construct your contract management arrangements to ensure your duties are met. Thanks.
Thanks, Bev, for the comprehensive overview. As mentioned, my name is Michael Evans. I'm the Director of the Regional Operations WA and Major Infrastructure Projects teams. I'll be providing a general overview of Comcare's regulatory approach in terms of our inspectorate response, and we'll close with a scenario involving a contractual chain. So, what can you expect from Comcare when an inspector calls following an incident involving contractors? Upon receipt of an incident notification, an assessment will be made to determine, amongst other things, the identity of the Commonwealth PCBU, the identity of the contractor involved, the nature of the work activity, including the circumstances and any known causal factors of the incident, any corrective preventative control measures to mitigate recurrence of the same or a similar type of incident occurring, circumstances associated with jurisdiction. For example, aside from confirming that the Commonwealth PCBU or non-Commonwealth licensee falls within Comcare's jurisdiction, we'll also seek to determine whether the contractor is a state-based non-Commonwealth PCBU. I'll refer to them as the contracting PCBU. Incidentally, where a contracting PCBU is involved in a work health safety incident, we would request that the nature of their involvement and identity to be made known within the incident notification to help inform our triaging process. For notifiable incidents in particular, we would also seek to understand whether the relevant state WHS regulator has been notified of the incident by the contracting PCBU. If notification hasn't occurred, we'd encourage the Commonwealth PCBU to ensure that it does. The reason I raise this is a circumstance of this kind potentially results in a co-regulated or cross-jurisdictional workplace. This essentially means that both the relevant Commonwealth and state work health safety regulators may have jurisdiction over various aspects of the PCBUs, including their respective business or undertaking. Following triage of an incident notification, and on the basis that inspectorate action is initiated, the Commonwealth PCBU will be notified by Comcare to advise of this course of action. What this means in practical terms is that an inspection will be commenced by a Comcare inspector. The purpose of conducting an inspection includes assessing compliance of the Commonwealth PCBU's duties as contained within the Work Health Safety Act and/or Work Health Safety regulations, and to ensure that appropriate control measures have been implemented in order to mitigate recurrence of a further incident. Where a PCBU omits to implement control measures following an incident, an inspector will determine an appropriate regulatory response in accordance with Comcare's compliance and enforcement policy. By way of example, this could include the issuance of non-disturbance, improvement, or prohibition notices. In having regard to the scope of an inspection, Comcare's intention is to focus their regulatory activities on the work health safety duties of the Commonwealth PCBU in question. In doing so, Comcare may engage with the respective state work health safety regulator to determine what action, if any, the state regulator may be undertaking in relation to the contracting PCBU. It's noteworthy that parallel inquiries could also be undertaken by both regulators in relation to the same incident, although the scope will likely differ. In considering specific lines of inquiry that an inspector may pursue, the approach is not prescriptive, as generally speaking, no two incidents are exactly the same, and some variation may be necessary. It's also important to note that Comcare is a systems-based regulator, and our regulatory approach is likely to involve a detailed assessment of the system of work associated with the work health safety incident or concern in question. In order to provide a general overview of our reactive response, the following methodology should provide some clearer guidance as to what information an inspector seeks to obtain as part of their assessment. The methodology reinforces the contractor management principles referenced earlier in this presentation. Influence and control. What level of influence and control does the Commonwealth PCBU have over the work being performed by the contracting PCBU on their behalf? Does the Commonwealth PCBU have contractual control and/or practical control over the work being performed? For example, does the Commonwealth PCBU have subject matter expertise over the work? Have they outsourced to an expert contractor as they don't have the expertise themselves? Or can they stop or direct the work to be performed in any particular manner? Regardless of the circumstances, we know the Commonwealth PCBU cannot transfer or contract out of their duties and must ensure an adequate system is in place to manage all workers, including their contractors. I'd just like to flag that the level of monitoring and oversight is dependent upon what's reasonably practicable for the Commonwealth PCBU to do in the circumstances. There's also somewhat of a sliding scale that can be applied as per the contractor continuum model, which was referenced earlier. For example, a Commonwealth PCBU without expertise that engages a contracting PCBU with expertise is entitled to have increased reliance upon that contractor. Having said that, given the Commonwealth PCBU cannot transfer their duty, they still need to demonstrate in a reasonably practicable sense what they've done and continue to do in order to discharge their work health and safety duties. In considering what a Commonwealth PCBU can do to discharge its work health and safety duties when engaging a contracting PCBU, we've outlined various principles in earlier discussion as part of the Managing Contractor Safety Model. Without reiterating the specifics, I'd strongly encourage you to review the essential elements of the model to gain a deeper understanding of its purpose and implementation. In summary, we would consider that adhering to the model would assist the Commonwealth PCBU in terms of undertaking their due diligence or having regard to foreseeability of incidents occurring and the application of reasonably practicable control measures in the circumstances. It's also important to note that this type of information is what an inspector will likely seek to obtain as part of their overall compliance assessment of the Commonwealth PCBU's contractor management system. Depending upon the circumstances and the scope of the inspection, the inspector may seek to review all of these components or only the elements that are applicable to the matter at hand. In any event, the inspector will be mindful of potential regulatory burden and will aim to minimise inquiries to within a reasonable and proportionate manner. At the conclusion of an inspection, the inspector will provide the Commonwealth PCBU with an inspector report. The inspector report will articulate the inspector's findings and observations associated with their compliance assessment, including any corrective actions that may apply. Where corrective actions do apply, an inspector may undertake a future verification inspection to ensure that appropriate control measures have been implemented. Separate to inspections, I'll just take this opportunity to advise that where the circumstances dictate, an inspection may be escalated to an investigation process. Investigations aren't as commonplace as inspections and are generally reserved for matters of serious non-compliance that may warrant prosecution. So that's a lot of information to contemplate, but probably a good segue into discussing some different examples involving the contractual chain scenarios. I'm going to talk you through one example involving the engagement of a principal contractor. Then I'll hand you over to one of my colleagues to talk you through a couple additional examples. The Department of ABC is a Commonwealth PCBU. ABC is a public service department that provides general support services to Australian residents. ABC's head office is at capacity, and ABC has decided to have an additional office constructed nearby. ABC has appointed state contractor XYZ Construction as the principal contractor for this construction project, which is valued at $2 million. XYZ has in turn engaged the services of various state subcontractors to undertake construction activities. As a Commonwealth PCBU, ABC has obligations under work health safety legislation to ensure the safety of its workers, including all state contractors, so far as is reasonably practicable. As part of their duty, ABC has established oversight arrangements of XYZ, which includes conducting regular work health safety meetings and auditing processes. XYZ is responsible for the management of day-to-day work health safety matters, including the management of subcontractors on site. In addition to the specified duties under work health safety legislation as a principal contractor, ABC, through its contractual arrangements, has stipulated various conditions on XYZ. XYZ obligations include, but aren't limited to, engaging the services of subcontractors, consulting with PCBUs and workers, investigating work health safety incidents, and managing work health safety risks so far as is reasonably practicable. Looking at the contractual chain diagram, this example involves a Commonwealth PCBU, a state-based principal contractor, and state-based subcontractors. Although somewhat broad in nature, the methodology is based upon a common scenario that is routinely seen across Comcare's jurisdiction, particularly in the major infrastructure project space. So in considering the nature of this example, I'll touch on some of the key contractor management principles and cover how they apply in the circumstances. ABC is a Commonwealth PCBU and owes work health safety duties to all workers, including XYZ and its subcontractors. ABC commissioned a construction project valued at more than $250,000 and engaged XYZ to be the principal contractor. In doing so, ABC has authorised XYZ to have management and control of the project workplace. XYZ in its own right also becomes a PCBU for the purposes of the Work Health Safety Act and owes work health safety duties to subcontractors, including their workers. It's important to note that while both ABC and XYZ owe work health safety duties, neither can transfer or contract out of their respective duties. Additionally, both ABC and XYZ arguably owe shared work health safety duties with regard to the construction project. This is where it becomes critical to have clear contractual arrangements and a robust work health safety management system in place. It also assists in delineating the roles and responsibilities of all duty holders within the contractual chain to ensure a detailed understanding of all elements of the contractor management model. ABC is required to consult with the project designer regarding work health safety hazards and must provide a report of these hazards to XYZ. Of note, whereby high-risk construction work is to be undertaken, ABC must also ensure that a safe work method statement is prepared, identifying hazards, risks, and controls. This should be provided to XYZ, and work must be completed in accordance with this methodology. This also requires ongoing review and revised controls, so far as is reasonably practicable. As ABC is not a construction specialist, it's entitled to place more reliance upon the expertise of XYZ, which effectively limits ABC's level of influence and control. As XYZ holds specialist level construction expertise, it maintains a high degree of influence and control of its subcontractors and the day-to-day operation. In any event, everyone in the contractual chain owes duties and must consult, cooperate, and coordinate on all work health safety matters associated with the construction project. In bringing this to a close, Comcare's focus on this scenario would be to assess whether ABC took all reasonably practicable steps to ensure the health and safety of XYZ and its subcontractors. In doing so, Comcare would seek assurance that ABC has appropriate systems in place and they're functioning effectively. Elements of the system that Comcare would seek information from ABC in order to assess their compliance would include evidence of the tendering or procurement process to determine whether XYZ are an appropriately qualified and competent principal contractor, a copy of the contract between ABC and XYZ to understand the arrangements, roles and responsibilities of all duty holders concerned. This would also assist in understanding ABC's due diligence and level of influence and control, including any directions or decisions they're entitled to apply to XYZ. An understanding of the work health safety management system in place, including copies of relevant designer reports and safe work method statements. An understanding of supervisory, monitoring and oversight arrangements of subcontractors, including documentary evidence of site inspection, auditing arrangements, minutes from work health safety meetings, and applicable control measures in response to both a proactive and reactive oversight regime. While this list might not be exhaustive, I hope it provides a more detailed insight into the various duty holder obligations and inner workings of Comcare's inspectorate. So that brings me to the end of this scenario. I'm now going to hand you over to my colleague Phil Devaney to work through some additional examples. Phil has significant inspector experience in contractor management, and his examples have considered the broad range of questions received during the registration process for this webinar.
Good afternoon. Thanks for joining us today to discuss some of the challenges involved with contractor management. My name is Phil Devaney, and I'm currently the Acting Assistant Director of Regulatory Operations with TAS. I'm here today to provide you with some brief case studies of incidents that have occurred in our jurisdiction, presenting two scenarios that are common amongst our PCBUs. I've combined multiple incidents into each scenario to create an opportunity to advise what the PCBU could have done to ensure the safety of their contractor workforce. This advice is of a general nature and does not incorporate all aspects of what might be required for your specific contractor relationship. These case studies are a PCBU engaging workers on the basis of extra personnel for a task that they regularly and historically perform themselves. An incident where a PCBU engaged a business to perform a task they do not have the facility or necessary expertise to undertake, for example, ad hoc tasks or maintenance. The first case study involves a PCBU who has a long history of performing the task being undertaken, but requires contractors to be effectively engaged on a full-time basis to assist in the completion of their workload. This type of arrangement is typical amongst telecommunications, logistics, and postal PCBUs with large contractor workforces, and provides the PCBU the opportunity to be involved in all aspects of the work, from contractor selection, onboarding, risk analysis, instruction, training, through to supervision. The first scenario is where a contractor was performing work on behalf of a PCBU when they were involved in a serious incident. The worker was taken to hospital in a serious condition. The inspector asked the PCBU what work health and safety documentation the contractor had in place prior to the incident and was told the contractor had no work health and safety documentation to speak of. When questioned about what the PCBU does to verify a contractor's competencies and safe system of work prior to engaging them, the PCBU said that they supply the contractor with an onboarding checklist to provide information of what work health and safety policies and procedures they have in place. The PCBU provided the inspector with the checklist for the contractor, which showed the contractor did not have all the necessary safety measures and documentation in place. It was found that the PCBU had not confirmed that the contractor had implemented a safe system of work, nor had it provided the contractor with the necessary information to ensure the risks associated with the activity were eliminated or minimised. Further inquiries also found that the PCBU did not have an effective onboarding process for contractors. Although they did have a process, it was found that it was not implemented effectively in the vast majority of cases. It was adjudicated in this instance that given the PCBU's knowledge of the task, the ability to contractually enforce or direct how work is undertaken, and the capacity to recognise and implement reasonably practicable measures to eliminate or minimise the risk to workers, that the PCBU owed a high level of duty with respect to this incident, given they had a significant ability to direct, control, or influence how the work was undertaken, and substantial experience and knowledge of the task being performed. If we refer to the managing contractor safety model, we can quickly assess what the PCBU could have done to minimise the risk to workers prior to this incident and potentially meet their work health and safety duties. Looking at the scoping work and work health and safety requirements element of the model, the PCBU should have undertaken an end-to-end risk assessment of the task to identify any other potential hazards that may interact, raising the level of risk. The incident occurred due to two hazards interacting, and this had not been considered or addressed adequately by the PCBU. The PCBU also emphasised that the contractor had been working for the business for over 10 years with no incident. It is worth noting that familiarity or trust is not confirmation of an established work health and safety system or compliance with work health and safety duties. Moving on to the contractor selection element, the PCBU should have performed a more robust review of the contractor's safety management systems. Additionally, when it became aware that the contractor did not have an effective safety management system in place, the PCBU could have looked to engage a contractor with an established safe system of work in place. They should have also considered collecting and reviewing work health and safety documentation from the contractor prior to commencement. The PCBU did provide a work health and safety checklist to the contractor, with the responses indicating that the contractor was not prepared from a work health and safety perspective. They should have reviewed the work health and safety systems being implemented by the contractor to ensure they were meeting their duties and obligations stipulated under both the Work Health and Safety Act regulations and in the agreed contract. As for legal arrangements, a clear contract outlining work health and safety duties should have been developed, implemented and enforced. Moving on to onboarding and induction, there was an opportunity to implement a more defined process when onboarding, drawing a clear line from when the contractor is selected through to when the work is commenced. They should have ensured all PCBU staff know their roles and responsibilities with respect to contractor management, and to verify that this process is sufficient to test the contractor's work health and safety systems are effective. Planning a safe system of work is vital, and the PCBU should have provided more detailed information to the contractor about the risks apparent for the task being performed. Given the experience of the PCBU and the likelihood that the work health and safety policies had already been developed by the PCBU, they should have looked to verify that the contractor was implementing these policies and ensure that these policies are reviewed intermittently to confirm they remain effective. Additionally, the risk assessments and work instructions provided by the PCBU had not taken into account all of the hazards involved with the task being performed, and some of this documentation was found to have not been reviewed for over 10 years. It is imperative when providing safety advice to workers that it is reviewed at defined intervals to ensure that the most up-to-date safety measures are being implemented and to afford workers with the highest level of protection possible. Another missed opportunity was to consult with all parties prior to the task, to identify and address safety concerns as a group, utilising the knowledge and experience of all involved. In the contractor monitoring and supervision element, the PCBU should have implemented a regular audit schedule ensuring all elements involving contractual obligations are being met. They could have provided the contractor with a survey to enable and encourage opportunities for work health and safety feedback, attended site, or simply called the contractor as a part of a work health and safety review check-in. And finally, post-incident, when it was identified there were significant issues with the contractor management process, the PCBU should have acted proactively and taken actions to address the issue promptly, along with reviewing the task to identify opportunities for work health and safety improvements. Moving on to scenario 2, it's an instance where a PCBU engages an expert to complete a task in which they have insufficient experience or knowledge. This can be as simple as engaging someone to change a light bulb, all the way through to contracting a party to complete complex large-scale projects, where the PCBU's greatest area of influence is at the contractor selection onboarding phase. This specific scenario will present itself to a large range of PCBUs, given the need on occasion for all businesses to engage specialist licensed contractors for maintenance work, as an example. The PCBU engaged a contractor who then engaged a subcontractor to move large objects from one location at the workplace to another. This involved lifting the objects up a flight of stairs. During the process, the object fell and injured the worker. It was determined through internal investigation that an administrative error on the part of the subcontractor had occurred by failing to incorporate in the work order that the items to be moved would need to be moved upstairs and would require specific plant to do so. The worker involved was working on information that objects were to be moved on a flat surface and was not prepared for the task. However, when the worker arrived, he was offered a similar item of plant that was available at the workplace. He decided to use this item of plant, but subsequently the plant failed halfway up the stairs and injured him. The contractor was offered the opportunity to reschedule the task, but declined. The PCBU had consulted with the contractor on site and provided information that the task was to involve stairs, a detail that was missed by the subcontractor when completing the work order. The PCBU had limited control over the worker deciding to use the plan available on site, but potentially could have made further inquiries before the task began. 3 clear opportunities were available to potentially avoid this incident, which were to review the work order to ensure all details of the task were accurate and to verify that effective controls were implemented. Take the opportunity to reschedule the task when circumstances changed. Consult with all parties prior to the work commencing to ensure that the scope of work is clearly understood by all involved. Let's take a look at the managing contractor safety model again to see what could have occurred prior to the task being commenced. A defined scope of works would have identified the plant involved, which would have potentially ensured that the worker arrived on site with the appropriate item of plant for the task. Earlier on in the contractor selection element, the PCBU could have ensured the contractor had available for use and users appropriate resources and processes to eliminate or minimise risks. Additionally, requesting and reviewing the work order may have ensured all details of the task were accurate and that effective controls were implemented. When planning a safe system of work, the PCBU could have requested further work health and safety information from the contractor, specifically a work instruction on how the task was to be performed prior to the task being undertaken. In closing, we note that consideration was being given to issue a safety bulletin to workers on this incident and any similar incidents that had occurred. Information about incidents should be conveyed to the work group exposed to the hazard, along with any revised controls. The PCBU should also review the incident and ensure that the contractor has implemented reasonably practicable controls to avoid reoccurrence. In summary, PCBUs play a vital role in the safety of contractors, whether with the initial onboarding or in the instance they have significant control over the undertaking being performed. PCBUs will always have some level of duty in these instances, and it is imperative that you are prepared by clearly defining roles, responsibilities and duties both internally and externally. I'll now pass over to Bev for our key takeaways from contractor management. Over to you, Bev.
Thanks, Phil. I recognise there is a lot of information to consider with contractor management, so we've put together some key points we would like you to take away. A PCBU has a non-transferable duty to ensure, so far as reasonably practicable, the health and safety of all its workers, including contractors, while at work. An effective way to ensure a PCBU meets work health and safety duties owed to its contractors is through the establishment of a contractor management system. What has been described in this webinar is a very comprehensive contractor management system. However, not every contractor arrangement will necessitate this depth of scrutiny. What can reasonably practically be done by contracting PCBU to manage work health and safety risk associated with the contracted work will depend on, as we have discussed in the webinar, the relative expertise of the parties to the contract in the work being contracted, the control over the work being contracted and actual control, the type of contracting arrangement, labour hire versus expert, the length and complexity of the contracted work, and the level of work health and safety risk. As a contracting PCBU, you should give careful consideration to each element of the contract management system we have just discussed and determine in consultation with your contractor what you can reasonably practically do under each element to ensure your duties are met. Thank you. I'll now pass back to Tom.
Big thanks to Bev, Michael and Phil for breaking down contractor management for us. We'll just briefly pause for our first poll question, which is up on the screen there. The question is, do you feel you have an increased understanding of the shared duty and monitoring requirements when engaging with contractors? Do you feel you have an increased understanding of the shared duty and monitoring requirements when engaging with contractors? Okay, so that's a yes and no. Okay, looking at the responses now, are very good to see that 95% at the moment feel that they do. I think we have to recognise there was quite a lot of information to take in there and to digest. But don't forget, this webinar recording will be available for your future reference. And I think this will have been a success, even if it just raises and piques the interest more of you and prompts further questions. We'll use this, the questions that are being raised, the discussion points, to feed into some of our material. And we'd also welcome you to put that into the feedback form later on. Okay, now moving to a second poll question. How confident are you in your current understanding of expectations from inspectors following an incident involving contractors? How confident are you in your current understanding of expectations from inspectors following an incident involving contractors? Okay, let's have a look at that poll. Okay, mixed bag there. Somewhat confident seems to be the majority there. Again, it's a lot to cram in and a lot to respond there, but I would recommend that you go back and look at those, break down presentation, break down the sections that were spoken to, and look at them with a bit more time. Okay, thank you. So thanks for everyone for your answers. It's important for us to know this feedback to help shape our future webinars and events. So we're going to switch gears a little now and move on to Peter, who's got the scoop on the latest for the regulatory process enhancements. It's all yours, Peter. Thank you.
Thanks, Tom. Good afternoon or good morning, depending on where it finds you in the country, or overseas if you're overseas. Appreciate the opportunity to provide you with an update in relation to some proposed amendments to Comcare's regulatory processes. As with all organisations, Comcare is continuously reviewing and enhancing its regulatory process, or its processes. We are currently reviewing and updating our processes associated with the notification of WHS incidents and concerns. This includes the method used to triage WHS notifications and concerns, which is effectively the process used by Comcare to assess and prioritise its regulatory response to notifications. And we are also reviewing what information needs to be in those WHS notifications or concerns. So in other words, what feeds the triage process. You can anticipate further changes in the future to WHS notifications in relation once the revised notification requirements for psychosocial incidents are endorsed by government, and we expect that to occur in the next 12 to 18 months. So let's consider the triage process review and what's happening with that. Comcare receives thousands of WHS notifications and concerns every year. It is not possible to initiate an inspection into every event, and nor is it necessary. PCBUs should be capable of effectively responding to most incidents without the requirement for regulatory intervention, and Comcare's triage model seeks to acknowledge this and promote this concept of self-regulation. Comcare will continue to apply its current risk-based triage process to prioritise efforts and determine the appropriate regulatory response in the circumstances. The review really seeks to refine rather than replace that approach. In refining the triage process, Comcare seeks to achieve several objectives. The review aims to encourage compliance and self-regulation by primarily focusing on the application of WHS risk management principles relevant to the notified matter. The focus on the application of risk management will also assist us in being more efficient. We aim to increase the proportion of inspections where we improve health and safety by detecting non-compliance or opportunities for better practice. A key area of focus will also be ensuring that the PCBU has eliminated or controlled the relevant WHS risk. We are aware of the potential impact to PCBUs to the potential increased information requirements. So we are seeking to balance the requirements with the potential impacts. We aim to minimise the impact on PCBUs to the extent possible. For example, by providing inspectors alternative resolution processes outside of initiating an inspection where the circumstances indicate that this is a reasonable regulatory response. Comcare will always need to initiate some form of reactive responses, but Comcare's strategic objective is to reorient a greater proportion of its regulatory effort towards proactive activities. The aim being to prevent or minimise harm before it occurs rather than responding after an event. The triage process will support this, in part, by reducing unnecessary engagements. So what does the proposed triage process look like? The triage process itself is quite complex, as you would appreciate, and in the interest of time, I'll provide an overview of the critical considerations. The initial step is to confirm jurisdiction. Without jurisdiction, we would not progress with the matter. After confirming jurisdiction, we will then prioritise response to fatalities and those matters where, despite the outcome, death was reasonably likely to have occurred. For instance, a person could possibly walk away from a fall off a 3-storey building, but that is not the usual or anticipated outcome for such an event. We will also prioritise responses to matters that relate to a regulatory priority. These priorities are generally focused on situations that are identified as causing significant harm in the jurisdiction, but they may be more proactive in nature, effectively ensuring that emerging issues are curtailed before they result in harm. After this, the triage process requires consideration of several other factors, those being whether the PCBU has previous non-compliances related to a similar matter, whether the resources and controls in place at the time appear reasonable, such as being reflective of industry norms, whether the event or its consequences were unexpected for the PCBU or the activity conducted. And an example of that is that we would make additional inquiries if an agency such as Comcare had an incident involving parachute injuries. Inspectors don't generally parachute into locations, so we would be querying why Comcare would be having a parachute injury or incident. Another factor is the capacity of the PCBU to respond to the matter, including consideration of the actions taken and planned at the time of notification. Critically, as mentioned previously, we will seek to confirm that the PCBU has eliminated or controlled the risk to health and safety. This includes considering interim controls pending more in-depth analysis by the PCBU, which is usually what we find in most incidents, because there hasn't been sufficient time to develop the enduring response. The final consideration is whether there is sufficient information to inform the assessment. If not, then initial inquiries may be made to resolve these deficiencies. Once a decision to initiate a regulatory response is made, the assessor must determine the appropriate type and level of response in the circumstances. And as I said previously, this can now be varied away from just doing inspections or investigations. It might be a different type of engagement. So this is a brief overview. It is important to note that we are looking for anomalies, and a single anomaly does not trigger an inspection or an investigation. So what are the differences you may experience? There are several differences you are likely to notice due to the revised risk-based triage process. Again, Comcare will prioritise incidents where the information provided indicates an uncontrolled or undefined risk to health and safety remains. We are looking to see that the PCBU has examined the incident, the controls that were in place, and, based on a preliminary assessment, initiated a response that has eliminated or controlled the risks so far as reasonably practical. We will also prioritise incidents where the information indicates that there is a higher potential for non-compliance to have occurred. For example, we will consider the controls in place at the time and whether they appear reasonable, whether the severity of injury is anticipated for that type of incident and the controls in place, or whether the incident relates to previously identified non-compliance, as mentioned earlier. As a regulator, we cannot make assumptions about what has occurred and the PCBU's response. We will prioritise our regulatory efforts to those notifications where the information provided is not sufficient to enable us to make an informed decision. To avoid initiating unnecessary inspections, we will seek to clarify any gaps or points of confusion in the information provided, but if we cannot resolve this in a timely manner, we will initiate an inspection. We acknowledge that not every notification warrants the initiation of an inspection or investigation. we are affording greater flexibility to inspectors to respond to notifications in a manner that is tailored to the circumstances. This could include providing information and advice about notification requirements if there was a late notification, as opposed to doing a complete inspection into that matter, or linking up a PCBU with a peer organisation who we believe has sound policies, procedures or practices, or has information that could benefit the PCBU that's had the incident, or it may involve referring a WHS concern to a PCBU for resolution, where we believe that this is more appropriate. As with all triage processes, the revised approach is dependent upon the information provided, and this leads us to the next component, the review of the information required in WHS notifications and concerns. Everyone will be familiar with the term garbage in, garbage out. The ability to effectively triage WHS notifications and concerns is dependent upon the information provided. The approach seeks to balance the need for information and the impost on the PCBU. We cannot ask for everything, and nor is it reasonable to expect a PCBU to know everything when they must notify immediately. In the first instance, we are seeking to inform our regulatory decision-making processes. This includes the triaging of responses to WHS notifications and concerns, but also completing related decisions, such as determining whether to provide scene release. In this regard, we effectively need information to enable us to determine whether we need to initiate regulatory action to secure health and safety and or secure potential evidence. We will refine the existing WHS notification by adopting a more risk-based focus and a more logical flow to the form. The amendments will also indirectly assist in promoting compliance and self-regulation. The information required will prompt PCBUs to consider and complete relevant actions in response to notifiable incidents, for example, reviewing existing controls. We are also revising the current guidance for WHS concerns. The intent is to provide clearer guidance through establishing specific forms. So what are the major differences we anticipate in the notification form? We anticipate several major differences with the revised WHS notification. It will clarify the information required when making immediate and written notifications, including providing additional guidance for each section of the form. This will assist PCBUs to notify Comcare in a timely and effective manner, reducing the need for clarifying questions post-notification. The form will focus on considering WHS risk, seeking to understand what risk eventuated or was realised, how the PCBU sought to control that risk prior to the incident, the PCBU's initial or preliminary assessment of why the incident occurred, what the PCBU has done to eliminate or control risks, and why the PCBU believes that the risk is now controlled. We will also seek to align the logic flow of the form with the general risk management process and incident response process. This will hopefully assist those completing the form. You can anticipate questions, as I've just gone through, asking for a description of the work being undertaken and the workplace, a description of the incident, the immediate workplace response by those in the workplace, controls in place at the time of the incident to prevent the incident and or minimise harms, the preliminary assessment of the cause or contributing factors, actions taken to prevent recurrence and or minimise harms in future. And that includes the immediate response and the planned response. And finally, you can anticipate us seeking confirmation that the risk is now eliminated or controlled to the extent practicable. We also intend to afford PCBUs the opportunity to provide an explanation for any missing information or exceedances of prescribed timeframes. This too will reduce the need for follow-up inquiries and prevent unnecessary inquiries into potential failures to meet notification obligations under Section 38. In summary, the revised form focused on understanding the hazards in place at the time, how the PCBU was managing that hazard, how it responded to the incident, and whether the PCBU has taken action to prevent recurrence. If I could just make a general comment, less is not more. Regardless of the structure of the WHS notification, the clearer and more comprehensive the explanation, the less likely it is that Comcare will need to make follow-up inquiries or initiate inspections. Now, as mentioned previously, we are also seeking to revise our requirements for submitting WHS concerns. The revised approach to WHS concerns will provide a more structured approach for obtaining related information. The intent is to provide dedicated forms for submitting WHS concerns. The forms will be similar to that used for WHS notifications. We anticipate using different forms for different types of WHS concerns. For example, the form for raising a request for regulatory assistance under the WHS Act, e.g. for example, in relation to issue resolution under Section 82, would be different to that for raising a more general WHS hazard or issue. A more structured approach will lessen the impact on those submitting WHS concerns while improving our ability to determine an appropriate regulatory response in the circumstances. The guidance will explain the various avenues for resolving WHS concerns. A particular element of that is that it will reinforce the importance of using available processes and procedures to raise WHS concerns with the PCBU in the first instance. We will continue to encourage resolution of concerns at the worker PCBU level where practicable. That basically brings me to the end of my presentation, or brief presentation as it is. In summary, Comcare is revising its triage processes to assess and prioritise its regulatory response to WHS notifications and concerns. To support this process and related decisions, such as scene release, Comcare is also seeking to revise the information required within WHS notifications and WHS concerns. And finally, the approach seeks to enable Comcare to apply its risk-based approach to regulation while minimising the impact on PCBUs and those raising WHS concerns. I'll now hand back to Tom. Thank you.
Thank you, Peter. We now have the final poll question available, which is how confident do you feel about understanding the revised work health safety notification triaging model and its implications for incident reporting to the regulator? So appreciate your attention there. So somewhat confident, sort of 50%. That's good to see. I think appreciated Pete, imagining a Comcare inspector parachuting in, but it took away from this. We really do. It's the sufficient information in to inform our assessments. So the actions you're taking are very important. Garbage in and garbage out was something else that took away from that. So we just need as much information as we can to effectively triage and reduce any unnecessary burden, administration burden. Thank you, Peter. Unfortunately, looking at the clock here, it's looking like we've run out of time to address the questions individually. So I apologise for that, but please rest assured your questions are valuable to us, and we recognise the depth of curiosity and interest that within the audience, and we're committed to incorporating your queries into future webinars and guidance material. And so as we're approaching time, I might conclude the webinar by asking our final poll question. Overall, how satisfied were you with this webinar? Give us a bit of a sense check before we ask for your feedback in the survey. But thank you very much for your responses there. It's valuable to get this feedback. The webinars, we learn from all of them. Timing is something we'll take on board. The number of questions that come through, it's all great to get this feedback. So thank you for taking the time to do that. On behalf of us all, I'd like to thank all our presenters for giving their time so generously and share their insights with us today. And thank you all in the audience for your questions, for your participation in the web polls and in the chat. Your engagement is what makes these events come to life, and we really appreciate it. As I said earlier, your feedback is very important. It shapes the way we deliver these events, and it provides input to what themes and topics we present on in the future. There is a QR code on the screen now that'll take you immediately to a short survey, which is also available in the chat now, along with some resources. So we'll also send you an email after for those who would prefer to do it later. But we encourage you to answer it now before logging out of the event. If you have any further questions to our team, you can reach out to the Work Health Safety Help Desk, the Comcare's WHS Help Desk, or by calling the number or through the email address you can see on the screen. The recording of this webinar will be available on our website in the coming weeks if you've registered for the event, and you'll be notified when these and the resources have been uploaded. A final reminder, if you'd like to stay in touch with the work Comcare is doing, including any events, guidance and resources, be sure to subscribe to our e-news or follow us on LinkedIn. Thank you again for joining us, and have a great day and stay safe. Goodbye.